Virginia just passed a gun law that could turn you into a felon overnight, even if you've owned your firearms legally for decades. One misdemeanor conviction and you lose your Second Amendment rights for 3 years. Own a standard magazine? Criminal. Buy a rifle with a pistol grip? Arrested. Today I'm breaking down the 7 most dangerous sections of Virginia House Bill 217 that could cost you your freedom, your property, and your constitutional rights. By the end of this video, you'll know exactly what's in this bill, what it means for gun owners, and how it could spread to your state. This isn't theory. This is law that's about to take effect, and it's already destroying the rights of law-abiding Virginians right now. Number 1. The complete redefinition of what Virginia calls an assault firearm. This is where the entire bill starts, and it's the foundation for everything else that follows. Under HB 217, the definition of assault firearm gets massively expanded to include firearms you currently own, have owned for years, and thought were completely legal. Here's how it works. A firearm becomes an assault firearm under this bill if it meets these criteria. It's semi-automatic, it's centerfire, it's capable of accepting a detachable magazine, and it has any one feature from a long list of cosmetic or functional characteristics. We're talking about threaded barrels, flash suppressors, muzzle brakes, compensators, folding stocks, adjustable stocks, pistol grips, suppressors, or simply being designed to accept any of these features. Let me be crystal clear about what this means. These are not rare features. These are not military-grade specifications. These are standard, commonly owned features on millions of firearms safely owned and safely used across the entire country. A threaded barrel? That's on most modern pistols and rifles. A pistol grip? That's basic ergonomics. An adjustable stock? That allows the firearm to fit different body sizes safely. This bill isn't targeting machine guns or rare weapons. It's targeting ordinary rifles, ordinary pistols, and ordinary shotguns owned by law-abiding Americans. The consequence here is immediate and severe. The moment this bill takes effect, firearms that were legal yesterday become assault firearms today. That means every provision of this bill, the criminal penalties, the transfer restrictions, the age limits, the confiscation rules, all of them apply to your currently legal firearms. Your AR-15? Assault firearm. Your Glock with a threaded barrel? Assault firearm. Your hunting rifle with an adjustable stock? Assault firearm. Here's what you need to understand to protect yourself. First, inventory every firearm you own right now and identify which ones would meet this new definition under HB 217. Second, document your ownership with receipts, purchase records, and photographs that creates a paper trail showing you own these firearms before any ban took effect. Third, understand that this redefinition is the trigger for every other section of this bill. So if your firearm meets this definition, you're subject to all 7 sections I'm covering today. Fourth, contact the Virginia Citizens Defense League immediately and get involved in the legal challenges to this bill, because this redefinition cannot withstand constitutional scrutiny under the Bruin Standard. Remember, we're breaking down all 7 sections that turn gun owners into criminals, and this redefinition is just the beginning. Number 2, making it a criminal offense to buy, sell, or transfer firearms. Section 2 of HB 217 does something that should alarm every single gun owner in America, not just Virginia. It makes it a Class 1 misdemeanor to sell, import, manufacture, purchase, or transfer any firearm that meets the assault firearm definition we just covered. Let's walk through what this actually means in practice. You see a rifle you want to buy at your local gun store. It's a semi-automatic rifle with a pistol grip. Under the old law, it was completely legal. Under HB 217, the moment you complete that purchase after the effective date, you have committed a Class 1 misdemeanor. The dealer who sold it to you? Also guilty of a Class 1 misdemeanor. The manufacturer who made it? Guilty. Every single person in the supply chain becomes a criminal. But it gets worse. This isn't limited to commercial sales. This applies to private transfers between family members, gifts, inheritances, everything. Your grandfather wants to pass down his hunting rifle to you, and that rifle has a detachable magazine and a threaded barrel? Illegal transfer. Both of you are now criminals. You want to sell a firearm you've owned for 20 years to your neighbor? Criminal act for both parties. The penalties here are devastating. A Class 1 misdemeanor in Virginia carries up to 12 months in jail and a fine of up to $2,500. But here's the real kicker. Once you're convicted of this misdemeanor under HB 217, you trigger Section 4 of this same bill, which we'll get to shortly, that prohibits you from possessing any firearm for 3 full years. So buying one rifle lands you with a criminal record, potential jail time, thousands in fines, and a 3-year ban on all firearm possession. Your solution path is narrow but critical. First, if this bill becomes law, do not purchase, transfer, or accept any firearm that meets the assault firearm definition after the effective date. The risk is too high. Second, if you currently own firearms that meet this definition, do not sell them or transfer them to anyone, even family, until the legal challenges are resolved. Third, document everything you currently own with dated evidence so you can prove ownership predates the law. Fourth, understand that this is a supply-side and demand-side ban. They're criminalizing both the buyer and the seller to completely shut down the market for these firearms. This section alone turns Virginia's entire gun market into a criminal enterprise, but the next restriction targets a specific group of Americans. Number 3, prohibiting anyone under 21 from purchasing, possessing, transporting, or transferring assault firearms. This section of HB 217 creates a complete ban for an entire class of legal adults, and it directly conflicts with recent federal court rulings. Here's the scenario this creates. You're 20 years old. You're legally an adult. You can vote in elections. You can sign legally binding contracts. You can get married. You can serve in the military and carry a rifle in combat. You can take out student loans. You can start a business. You can buy property. But under HB 217, you cannot purchase, possess, transport, or transfer any firearm that meets the assault firearm definition, even if that firearm was manufactured before the effective date of the law. Think about what this means. A 20-year-old Marine who served in combat overseas, who carried an M4 rifle in defense of this country, comes home to Virginia and cannot legally possess a semi-automatic rifle with a pistol grip. A 19-year-old woman who lives alone and wants to protect herself with a modern firearm for home defense is completely prohibited from doing so. An 18-year-old who inherited a rifle from a deceased parent cannot legally possess it for 3 more years. The legal consequences are immediate and severe. Possession by someone under 21 is a criminal violation. That means arrest, prosecution, criminal record, and all the penalties that come with violating this statute. But here's what makes this particularly egregious from a constitutional standpoint. Federal courts have repeatedly ruled that 18 to 20-year-olds are part of the people protected by the Second Amendment. The Fourth Circuit ruled on this. The Fifth Circuit ruled on this. The Bruin decision affirmed that rights vest at adulthood, which is 18, not 21. Here's how young adults in Virginia need to protect themselves. First, if you're under 21 and currently own a firearm that meets the assault firearm definition, you need to consult with an attorney immediately about legal options for transferring ownership to avoid prosecution. Second, understand that this is one of the most vulnerable sections of the entire bill from a constitutional standpoint, so legal challenges are coming. Third, if you're affected by this provision, document your situation and connect with organizations like the Virginia Citizens Defense League who are building legal challenges. Fourth, recognize that this sets a precedent. If Virginia can prohibit adults under 21 from owning common firearms, other states will follow. We're 3 sections deep, and every one of them creates new criminals out of law-abiding citizens. But this next section might be the most dangerous of all. Number 4, losing all firearm rights for 3 years after any misdemeanor conviction under this bill. This is the section that should terrify every gun owner because of how easily it can be triggered and how devastating the consequences are. Here's what HB 217 actually does. If you are convicted of any misdemeanor violation under this bill, not a felony, just a misdemeanor, you are immediately prohibited from purchasing, possessing, or transporting any firearm for 3 full years following that conviction. Not just assault firearms. Any firearm. Your handguns, your shotguns, your hunting rifles, everything. Let's put this in perspective with real-world examples. You unknowingly carry your concealed firearm into a building with a properly posted "No Guns" sign because you didn't see it. You're confronted, you're charged under a local ordinance, and it's tied to the HB 217 enforcement provisions. Misdemeanor conviction, 3-year firearm ban. You sell a rifle to your cousin in a private sale, and that rifle has a feature that meets the assault firearm definition. You didn't realize it qualified. Misdemeanor conviction, 3-year ban on all firearms. Now here's what makes this absolutely insane. In Virginia, there are misdemeanors for incredibly minor offenses. Some traffic violations are misdemeanors. Certain local ordinance violations are misdemeanors. The threshold for a misdemeanor conviction is extremely low compared to a felony. And under this bill, any misdemeanor conviction related to HB 217 violations triggers a 3-year loss of Second Amendment rights. The consequences go go beyond just the ban itself. During that 3-year period, all of your firearms can be seized and forfeited to the Commonwealth. That means law enforcement can come to your home, take every gun you own, and you have no recourse. Your $2,000 competition pistol? Gone. Your grandfather's rifle that's been in the family for generations? Seized. Your home defense shotgun? Confiscated. And at the end of the seizure process, those firearms are subject to destruction or disposal by the state. Here's your protection strategy, and you need to take this seriously. First, understand that this 3-year ban is not based on a violent felony standard or a dangerousness assessment. It's automatic upon any misdemeanor conviction under this statute. Second, if you're charged with any violation of HB 217, you must fight it with every legal resource available because the consequences extend far beyond the immediate charge. Third, document the location and condition of all your firearms now, with photographs and serial numbers, because if a seizure happens, you need records of what was taken. Fourth, recognize that this provision treats your Second Amendment rights as a state-issued privilege that can be revoked for paperwork violations, which is fundamentally unconstitutional. This is punishment by paperwork, and it's designed to discourage gun ownership entirely. But we're not done yet. The next section targets what you can buy. Number 5, banning the sale, transfer, or importation of magazines over 10 rounds. HB 217 doesn't just target firearms, it targets the magazines that feed them, and it does so in a way that makes standard equipment illegal. Here's the exact provision. The bill bans the sale, transfer, or importation of any magazine capable of holding more than 10 rounds if that magazine was manufactured after July 1st, 2026. Now you might be thinking, okay, so magazines manufactured before that date are grandfathered in. Not really, because here's the enforcement problem they've created. How do you prove when a magazine was manufactured? Most magazines don't have date stamps. They don't have serial numbers. They don't have manufacturing codes that indicate when they were made. So when law enforcement encounters a standard 30-round AR-15 magazine or a 15-round Glock magazine, how do they determine if it was made before or after July 1st, 2026? They can't, which means in practice, this ban applies to all magazines over 10 rounds because you cannot prove the manufacture date. Let's be absolutely clear about what a 10-round limit means. Standard AR-15 magazines hold 30 rounds. Standard Glock 17 magazines hold 17 rounds. Standard magazines for many pistols hold 12, 15, or 17 rounds. Home defense shotguns with extended tubes hold more than 10 rounds. This bill redefines all of this common equipment as contraband. And here's the constitutional problem that Virginia completely ignores. The Supreme Court has repeatedly held that arms in common use are protected by the Second Amendment. In the Heller decision, the court specifically noted that weapons commonly used by law-abiding citizens for lawful purposes are protected. Standard capacity magazines are overwhelmingly the most common magazines in circulation. There are tens of millions of them in lawful possession across the country. Banning them is a direct violation of established Supreme Court precedent. The consequences of violating this magazine ban are criminal charges, fines, possible jail time, and forfeiture of the magazines themselves. But it also contributes to the overall criminalization scheme of HB 217. If you possess a banned magazine, you can be charged, and that charge can lead to the 3-year firearm ban we just discussed. Your action steps are critical here. First, if you currently own standard capacity magazines, document your ownership now with dated photographs and purchase receipts showing you own them before any ban date. Second, understand that the burden of proof will fall on you to demonstrate the magazine was manufactured before the cutoff, so any evidence you can gather now is crucial. Third, do not purchase, sell, or transfer any magazine over 10 rounds after the effective date if this bill becomes law. Fourth, recognize that this ban ignores the Supreme Court's common use standard and is ripe for legal challenge. That's 5 sections down, and every single one of them criminalizes normal gun ownership. But the next section goes even further. Number 6. Destroying private firearm sales through mandatory background checks and dealer facilitation. This section of HB 217 fundamentally changes how firearms can be transferred between private individuals, and it comes with criminal penalties for paperwork errors. Here's how the bill restructures private sales. Every private transfer of a firearm must now go through a licensed dealer who facilitates the background check. You cannot sell a firearm directly to your friend, your neighbor, or your family member without involving a dealer, paying paying transfer fees, and completing all the same paperwork required for a commercial sale. But here's where it gets worse. The bill flatly prohibits private sales of any firearm that meets the assault firearm definition. Not regulated, not restricted, prohibited entirely. Let's walk through a real scenario. Your uncle wants to sell you his hunting rifle. That rifle has a detachable magazine and an adjustable stock, so it meets the assault firearm definition under Section 1 of this bill. Under the old law, this would be a simple private transfer. You pay him, he gives you the rifle. Done. Under HB 217, this transfer is completely illegal. It doesn't matter that you're family. It doesn't matter that you both pass background checks. It doesn't matter that the rifle is used for hunting. The transfer itself is prohibited, and both of you are subject to criminal prosecution if you complete it. For firearms that don't meet the assault firearm definition, you can still transfer them privately, but only through a dealer. That means you drive to the dealer, pay a transfer fee, typically $25 to $75 in Virginia. The dealer runs the background check, completes ATF Form 4473, logs the transfer in their bound book, and only then can the firearm change hands. Any error in this paperwork is a criminal violation. Fill out the 4473 incorrectly? Criminal violation. Does the dealer fail to log it properly? Criminal violation. The consequences here are both financial and criminal. Every private sale now costs you money in dealer fees and time in dealer facilitation. But more importantly, any violation of these transfer requirements results in criminal charges. And remember, criminal charges under HB 217 trigger that 3-year firearm ban we discussed earlier. Here's how you protect yourself under this new regime. First, accept that private sales as you knew them are over in Virginia if this bill becomes law. Second, for any firearm that meets the assault firearm definition, do not attempt any transfer whatsoever. The prohibition is absolute. Third, for other firearms, only complete transfers through a licensed dealer and ensure every piece of paperwork is perfect. Fourth, keep copies of all transfer paperwork because you'll need proof of legal ownership if you're ever challenged. This isn't regulation. This is elimination of the private firearms market. And the final section is where the real endgame becomes clear. Number 7. The confiscation and destruction provision. That's the ultimate goal of this entire bill. Section 7 of HB 217 establishes that any firearm, magazine, or accessory possessed in violation of this law is automatically forfeited to the Commonwealth and subject to destruction or disposal by the state. Here's how forfeiture works under this bill. If you are found in possession of a firearm that violates any provision of HB 217, whether it's a banned assault firearm, a magazine over 10 rounds, or you're under 21 and possess a prohibited firearm, that item is automatically forfeited. Not maybe forfeited, automatically forfeited. Law enforcement seizes it on the spot, and it goes into state custody. Once in state custody, here's what happens to your property. The Commonwealth can destroy it. They can dispose of it. They have complete control over firearms, magazines, and accessories that are forfeited under this statute. That $3,000 custom AR-15 you built? Destroyed. Those 30-round magazines you've owned for a decade? Destroyed. That suppressor you paid $200 for a tax stamp and waited a year for ATF approval? Destroyed. Now let's talk about the enforcement mechanism, because this is where things get truly dangerous. How does law enforcement determine you're in violation? They can conduct traffic stops and discover firearms during vehicle searches. They can respond to your home for an unrelated call and observe firearms in plain view. They can receive tips from neighbors, family members, or anyone who knows your own firearms. And under the broad definitions of HB 217, they can determine on the spot that your firearm violates the law. Here's the nightmare scenario that every Virginia gun owner needs to understand. You're involved in a traffic accident. Law enforcement responds. During the investigation, they observe a rifle case in your vehicle. They ask about firearms. You disclose that you have your rifle secured in the case. They ask to see it to ensure it's properly secured. You show them. The rifle has a pistol grip and a detachable magazine. Under HB 217, that's an assault firearm. If you purchased it after the effective date, you violated the purchase prohibition. The rifle is immediately seized and forfeited. You're charged with a violation. You face criminal penalties, and you're now prohibited from possessing any firearm for 3 years. The constitutional problems with this forfeiture scheme are massive. Under the Supreme Court's Bruin standard, the government must demonstrate a historical tradition of regulation that supports modern restrictions. There is no historical tradition of banning common firearms. There is no tradition of disarming adults under 21. There is no tradition of banning standard capacity magazines. And there is absolutely no tradition of seizing lawfully owned property and destroying it because politicians redefined its legal status. But here's the reality. Constitutional challenges take years to work through the courts. They cost hundreds of thousands or millions of dollars in legal fees. And during that entire time, gun owners in Virginia are subject to arrest, prosecution, and confiscation under this law. That's why it's critical to kill bills like this before they become law, not after. Your protection strategy is limited but essential. First, understand that forfeiture is automatic upon any violation. There's no judicial process, no hearing, no due process before your property is seized. Second, if law enforcement ever questions you about firearms, exercise your right to remain silent and request an attorney immediately. Third, do not consent to any searches of your vehicle, home, or property without a warrant. Fourth, document every firearm you own with photographs, serial numbers, and purchase records so if forfeiture occurs, you have evidence for legal challenges. This forfeiture provision is the end game. It's how they plan to physically remove firearms from Virginia gun owners. And once your firearms are in state custody, they're gone forever. Let's recap the 7 sections of Virginia House Bill 217 that turn law-abiding gun owners into criminals. Number 1. Redefining assault firearms to include standard features on millions of common guns. Your rifles, pistols, and shotguns become illegal overnight. Number 2. Criminalizing the purchase, sale, and transfer of these firearms. Buying, selling, or gifting them becomes a Class 1 misdemeanor. Number 3. Banning anyone under 21 from possessing these firearms. Legal adults lose Second Amendment rights for 3 years. Number 4. 3-year firearm ban after any misdemeanor conviction. One mistake costs you all gun rights for 3 years. Number 5. Magazine ban over 10 rounds. Standard equipment becomes contraband. Number 6. Eliminating private sales. All transfers must go through dealers, and assault firearms cannot be transferred at all. Number 7. Automatic forfeiture and destruction violates any provision and the state seizes and destroys your property. Any one of these sections could cost you your freedom, thousands in legal fees, and your Second Amendment rights forever. This bill is not about public safety, it's about control. It turns normal gun owners into criminals, punishes possession instead of behavior, and treats a fundamental constitutional right as a state-issued privilege that can be revoked at will. If you live in Virginia, contact the Virginia Citizens Defense League immediately and get involved in fighting this bill. If you live in another state, pay attention, because what happens in Virginia doesn't stay in Virginia. These bills spread. They're being pre-filed in other states right now. Don't let confusion about gun laws put you at risk. Subscribe to Guns Law Guide so you never miss an update that could keep you legal and protected. I break down bills like this every week so you can stay informed and stand up for your rights. Stay armed, stay free, and keep standing up for the Constitution.